Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as our coordinator for today's program, which is sponsored by Plunkett Cooney's Governmental Law Practice Group. Working as a public official can be a thankless job, fielding a never-ending list of constituent complaints, battling budget shortfalls, and responding to emergencies. In short, there's plenty of opportunities for municipal officials to fall into the proverbial hot soup issues of the day. So that's why we wanted to take time out today to present a program designed to guide municipal officials through some of these trouble areas and trying to keep them from getting burned euphemistically, of course, while serving in your official capacities. With us today for this important update are two of Plunkett Cooney's Governmental Law Practice Group members, Bob Marzano and Sidney Percelli, a current and former public official, respectively. They definitely understand the complexities and pitfalls of public service, so we're happy to have them with us. But before we get started, I'd like to take just a few minutes to provide you with some background about our firm and today's speakers. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 150 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our governmental law practice group includes more than 20 attorneys who provide in-house counsel and litigation services to municipalities. Their expertise ranges from drafting ordinances to assisting with intergovernmental agreements to defending litigation and everything in between. So, as I mentioned, we're joined today by Bob Marzano and Sidney Percelli. And for over 20 years now, Bob's served as in-house counsel and litigation counsel to municipalities in Southeast Michigan. He currently serves as Plymouth and Northville City Attorney, and he's handled the defense of numerous lawsuits brought against other municipal clients. Bob has particular expertise in the areas of zoning and land use, election law, intergovernmental agreements, and much more. Sidney Percelli has been working as an attorney in the private and public sectors for nearly 20 years. A former member of the City of Detroit Law Department, Sidney also has the distinction of having served as the second deputy commissioner of the Detroit Fire Department. Today, her practice focuses on all aspects of labor and employment law. Now, a few housekeeping notes about today's program. For our Q&A portion of the webinar, we're going to use our questions widget on your GoToWebinar navigation display. Please take a moment now to locate the widget and feel free to enter questions as they occur to you during the program. At the end of our presentation, we'll try to answer as many as possible, and we only ask that you pose questions of a more general nature versus getting into too much specific detail about your ongoing matters. Finally, I want to mention that today's session is being recorded, and that recording will be available on our event page on Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share the link or direct your colleagues to that page if they were unable to join us today. Thanks again for attending today's webinar. Now it's time to get started. So Bob, I'll turn over the program to you. Please take it away.
Thank you, John. First topic today that we're going to discuss is ethics. And as a municipal officer, you hold a special role. You're not only a citizen of the municipality you reside in, but you're also a public officer of the municipality you serve. In my 20-some years of being a city attorney for 2 cities, I often hear board members, commission members, council members saying, I'm nothing but a mere volunteer. And I remind them, no, you're more than a mere volunteer. You are now an official officer, whether it be elected or appointed of the city that you serve or the township you serve, and you have to act accordingly. So that is something very important to keep in mind as you walk about your municipality. You really do wear 2 hats. One, you're a citizen, but 2, you're also a public officer. And once a public officer, always a public officer. So just because you're not at a city council meeting doesn't mean you're not a city council member. If you're on the planning board or the planning commission and you're out to a local restaurant, although a citizen, you're still a planning commissioner and will be viewed by the citizens of your community as one as well too. So it's important to keep that in mind. It's not just merely a volunteer job that people sign up for to do. And this goes everywhere from being on the cemetery board to being on the city council. As a municipal officer, you are required to comply with all local, state, and federal laws. There is no immunity granted based upon just being a municipal officer. We will get into some liability issues later, but again, your position requires that you comply with all of these laws, including your own local laws. Many municipalities have what are called ethics ordinances, and what these ordinances are essentially guidelines for municipal officers and municipal employees as far as how they behave in their job or their role as an officer. I know that in some of the communities that I work with, there has been some very interesting situations that have developed, and unfortunately, we were not in a position to be able to deal with them because we didn't have an ordinance in place that would give us some basis to take action. Typically, the ethical issues that arise are ones that involve conflicts of interest. Obviously, we see on the news when you see a municipal officer taking a bribe, that's a violation of most ethic ordinances. A lot of times, hiring family members may be a violation of ethical ordinances. But the conflict of interest is really the big key one that you've got to watch out for. We all live, for the most part, most municipal officers reside in the municipality they serve, or in the city, township, or county that they serve. And there are times when issues come up when you may have to recuse yourself because you have a conflict of interest, whether it be personal or financial. Now, having an issue where you have to vote on raising water bills and you raise your hand and say, listen, I really don't think I should vote because I am absolutely against water bills being raised. Well, everybody in the municipality, for the most part, is too, so you fit in with the crowd. But if you own a car wash or some type of business that uses an enormous amount of water as part of your business operations and it affects your profits, that's a little bit different story. That might be a time where you recuse yourself. When you have an interest, whether it be financial or personal, in a matter before you, it's important that you bring it to the board's you bring this to the board's attention before any deliberations start, before the topic at issue hits the board. Because what often happens is I will get a call from someone who says, listen, I may have a conflict of interest. I'm on a planning commission, and we've had 2 public hearings on a zoning issue, and I think I should recuse myself because it's my neighbor and we can't stand each other. Well, that would have been something that would have been good to know, 2 meetings before the meeting started. Once you recuse yourself, you're out. You cannot participate in any deliberations, any decisions, anything to do with the particular topic at issue. I've seen some other strange things happen where a planning commissioner would step off the dais as a planning commissioner and represent a contractor before the planning commission at which that person served. And when the person was finished, go back to the dais and then resume her position as a planning commissioner. That can't be done. That's a conflict of interest. And most ethic ordinances would prohibit such behavior. Even though you're not voting on the actual issue, you cannot appear before your board on one issue representing someone else. And the reason's obvious. It gives that person what appears to be an unfair advantage over everyone else. Most of the issues that are covered in ethic ordinances are pretty obvious. My recommendation is if you have an ethics ordinance and you ever have a question or a problem or even a concern, one of those things where your intuition tells you something just isn't right, consult with your city attorney or your township attorney as soon as possible. Don't wait till you act, then consult with the attorney. Do it before. That way you keep yourself, as we say, out of the soup and out of trouble. Once you've acted. Then it becomes more of a reactionary type rescue where we do have to try to pull you out of the soup. And by that time, you're all wet and waterlogged. You don't want to have to get to that point. If you ask before, you'll stay out. If you do not have a local ethics ordinance, it is something I highly recommend considering doing. In today's day and age, where everyone's quite litigious, If you remove somebody from office and you don't have a basis to do so, or at least an ordinance in writing, they certainly can come back after you and claim that they didn't have due process or you didn't have the right to do what you did, and it can become a large political problem. Whereas if you have an ordinance in place and everything in writing, you're good to go. So with that, I'm going to turn over the next portion of the top or the speech today to my partner Sydney. Sydney, go ahead.
All right, great. Thank you, Bob. So just to let everybody know on the phone, what I'm going to talk about mostly today is how we're going to survive COVID over the next year. And COVID has become insidious in a lot of ways, and it's touching every single aspect of operations and what the employees are expected, how they're working, how they're coming to work, what's going to happen while they're at work. So because we're talking to cities today, I want to start off by talking about our relationship with the union. And it's the one that makes your eyes roll in the back of your head and it gets your blood boiling. But right now, we don't want to have that type of attitude. So I'm going to start off with your communication with the union. I talk to the union every day, yes, but are you really giving them a message? Are you giving them a plan? Are you including them in whatever the message is in your community, depending on the size of your community, depending on how many people have been affected by COVID, will depend on what is happening with your employees. How many people do you have to send home? How many people do you need to lay off? If you keep the union involved every step of the way, you're going to get less friction a year from now as things ease back into normal. So my first recommendation here is going to be just don't shut down. And the number one complaint that I'm hearing from the workers are that management does not have any clue of what is going on in the office. Management has no clue of what is going on in the street. And so that has been something over the years that I've learned and I've seen, that if you are in management, if you are an official, you have to be seen and you have to be heard by all of your employees, and that messaging will start with the union. So point 2. Right now, we're getting hot on the phone, we're getting hot in these video conferences, but I do not have any law that I can give you that says that telebargaining will be held to the same standard as in-person negotiations. What does that mean? That means that right now, the employer and the union, even though we're in this weird pandemic, neither side can insist on any certain procedure to be followed. So if you both agree to meet, that's wonderful. If one side doesn't agree and then we try to push forward with a formal negotiation, that may not hold up at MERC. And so what I would recommend here is that if there's going to be any discussions, that you get the union to agree to it. And that goes along with my next bullet point, which is don't be lax right now in terms of meetings, agendas, presentations. Write everything down. I'm a lawyer. I like to write everything down, and a lot of people don't. And when people are harried, when they're hurried, when they're in a panic situation, they're not sure what to do, then we start getting a little lax. We don't want to be lax, and we don't want to have handshake deals right now. Everything we do right now is going to create law. Everything that touches COVID is going to create law. So how we bargain right now, how we sit at the table, how we write things down is all going to eventually create law through the NLRB. Then it comes to public employment law as well. I wouldn't introduce new people to your bargaining team right now unless it's absolutely necessary, but use common sense. So if you're working with your public safety employees and they have, you have a doctor or you have a medical director that can answer questions at the table, you absolutely want to bring those key people in so that they can answer questions. Postponing negotiations. I would not recommend at any point right now that we sit down and do an A to Z negotiation on a collective bargaining agreement. Because for one thing, we don't know where everyone is going to be a year from now. We don't know what our budgets are going to be. We don't know how many people are going to retire. We don't know how many people we can even hire or keep on board, how many people will still be teleworking. So you don't want to overpromise or underpromise on anything that can come up in your collective bargaining agreement. But that being said, if you have an agreement that is going to expire this year, you must secure an extension. Okay, so if you're gonna run out of time in the next 3 to 6 months, get an extension for that 3 to 6 months, so that you know and can make a plan of what's going to happen for the long-term future. Be realistic about information requests from the union. If they ask for something that cannot be done because half your payroll staff is out, and so you can't run payroll for the entire city just to give 500 documents to the union, tell them that in writing. And instead of getting angry, try to understand what it is that they're really asking for. So my recommendation here, just make sure if something is going to expire that you get an extension, because if you don't, your management's rights clause and your no strike provisions, those will expire. So what that means is all of the salary and benefits will stay in place until the contract is renegotiated, but you lose management's rights, and we don't want that. Last thing, let's see, don't surprise the union with repeated unilateral action. So when all this broke out, hey, pandemic is going on, I have to keep all the workers safe, I'm going to send everybody home, we're going to start telework, we're going to change aspects of the workplace, we're going to start implementing safety measures. So that time has come and gone. Now we're at a time where we have to go back to bargaining, right? So this is no longer considered an emergency change. It is now sort of permanent in our workplace and how we're going to be living with COVID for some time. So how do you decide between what's a temporary situation and what is permanent? I would say if the situation is going to last until COVID is over, how do we measure that? We're either going to be medicated or we're going to be vaccinated. And then you'll know that's a permanent type situation that requires bargaining. So you don't want to get until next summer with a stack of grievances and work complaints on COVID-related actions that have been taken in the workplace. So re-engage the union, find out what's going on, find out the particulars to each individual group that they want to have feedback on, and invite them to sit down with you and memorialize all of those conversations. Do enforce work rules not affected by COVID. Some cities are still in a panic. There is no need to be in a panic. Everybody was already functioning before COVID came along, so now we have just layered this public health crisis right on top. Go back to your infrastructure. What is there? What is functioning? Rely on those things. Don't let the union divide you or play tit for tat with management. If you're giving the EMTs and police extra money and the trash guys, they're picking up the trash, are taking a pay cut, well, maybe you could cut them a break with their schedule. No, don't start dealing against yourself. You have to keep the infrastructure in place so that when eventually COVID ends, then when we're sitting at the table, we're starting from our original infrastructure and we haven't given things away. So a bargaining tip I would have here is considering a force majeure clause going forward. Generally has not been something that's been included in management's rights clauses in the CBA, but I like it because now we've seen what's happened. If you don't have one and it's only part of your charter, or if it's only part of an ordinance, it won't give you the wiggle room to move things around and make emergency changes in your collective bargaining agreement. So I would recommend that you put that in place. So Bob, I'm going to turn it back over to you.
Thanks, Sydney. Well, the next topic that we're going to talk about today is liability indemnity as a municipal officer. As a municipal officer, of course, you always have potential liability. Typically, that liability exists in your official capacity. If you do something outside your scope and course of what you're supposed to be doing as a municipal officer, you may have personal liability too. It depends on what the action is. Typically, we don't see that happen. When what the municipality will indemnify you for when your actions occur and what will not occur, depending on what it is that you've done. If you are caught up in a bribery scandal, you're not going to have indemnification. They're not going to pay for your criminal defense costs. If there's some type of contract you get the municipality in that may be outside the scope and course of your business, your role, and somehow liability is incurred onto the municipality, there could be a chance that you would not be covered. Typically, your coverage and your indemnification is always going to be present when you are simply acting in your capacity as what you do. If you say something bad or make a decision somebody doesn't like, or somebody claims you violated their rights based upon your official actions, you will typically always have cover and coverage from your municipality. That just comes with the job. Certain officers, too, may have qualified immunity under certain circumstances, such as prosecutors, police officers, depending on the situation. But it's important to realize that you're not above being sued. But it's also important to realize that anyone can file a lawsuit against anyone for any reason. And all they need to do is go down to the county courthouse, file a complaint, and pay a fee. The clerk doesn't check to see if there's any validity to the lawsuit or not. Oftentimes, you may, if you're sued as a municipal officer, be sued in your official capacity, and then for a plaintiff attorney to try to mess with your mind a little bit, they'll name you in your personal capacity too. Well, they can claim whatever they want. The issue is, what were you doing? If your actions were official actions on behalf of the municipality, then you're going to be covered most likely by your municipality. Now, if you have any questions regarding that coverage, I would highly recommend you speak with your risk manager or your municipal insurance representative to ensure that you are covered. There are situations where certain municipal officers are not covered under a city policy. I've seen situations where prosecutors are sued by a person who's unhappy with the results of some criminal matter they were involved in. The prosecutor did not have coverage through the city for that lawsuit. It's rare, but it happens. So I'd always make sure when you're serving on a board or a commission that your municipality provides you insurance coverage for your official actions. With respect to knowledge of potential lawsuits, as a officer of a city or township or county for that matter, it's important that if you have knowledge of a potential lawsuit, that information is transmitted to whoever needs to find, whoever handles those type of things. For instance, in a city, I would contact the city manager, in the township supervisor, and let them know, listen, there's a potential lawsuit on the horizon. I've heard this, or I've been told this, or I've observed this happen, and I can see where this is going. The reason being, it allows the municipality to begin to prepare for the lawsuit, to temper its actions towards being involved in litigation. It may result in a city council not making certain statements that it typically would make about a certain subject if it knows that this particular issue is going to be the subject of litigation in a short period of time. This is not something you want to keep to yourself. If you find out about it, it is vitally important that you let the powers to be know, or the people that handle that type of work for the municipality, of what's coming up. As far as liability, as to the cities, the townships, and yourself, my simple advice is think about what you're doing when you're engaging in an act, and always have the issue of potential liability on your mind. Now, it's easy for me to say as a lawyer because I'm always thinking about liability. I would say that 75% of what I do is trial law. So my thought process typically is, okay, if we engage in this act or we take this position, how is this going to play out in court? In the end, what will happen? And what's important for thinking that way is it lays the groundwork for how you may approach a situation and what you may do in advance of actually making a full decision. For one thing, it's nice to have a paper record of conversations you've had with an aggrieved party. It's nice to be able to show that you've complied with your own ordinances or your own regulations or your own policies before you take an action against a party that could result in litigation. When you're trying to make a decision, it may be worth consulting with your legal counsel to say, listen, what legal ramifications are there if we choose choice A over choice B, or if we just don't do anything at all? Unfortunately, as politicians and political persons like yourself, you're in a different world than attorneys. If it was up to me, you would never speak to the press. You would really never speak to anybody. That way, you're never liable for anything. However, I understand you can't operate that way. So there's got to be a happy medium that's found in there. But the issue of just running wild and ignoring any potential consequences, especially when it comes to issues of liability, is a big no-no and will become a big problem for you. One of the things that one of my city managers always tells the other board members and officers is, listen, unless you want to spend 5 hours with Bob at his office preparing for a deposition and then sitting through a 2-hour deposition where they ask you every question about every decision you've ever made in your life, it's important that you give this stuff thought, because you do not want to end up where that is. Now, granted, if you do, that's fine. That's what I do for a living, and we'll have you well prepared and feel very comfortable going through the depositions, but nobody wants to be deposed. Nobody wants to be an actor in a lawsuit if they don't need to. The time to avoid that type of fun is before you act, not after you act. And I know that's kind of a recurring theme I keep bringing up, but it's so hard to not engage in certain activities, especially when it's, a gut reaction to something someone says or does. If you can just step back, let's think about it before we act, it can save a lot of time in the future. So with that, I'm going to turn the podium back to, or I guess the phone back to Sydney. Sydney, you're next.
Okay, thanks, Bob. So I think what Bob was just saying is just so important, because as we've seen for the last 3 to 5 months, the laws are continuously changing. Well, how am I supposed to know how to make a decision or think about making a decision when I don't even know what the law is? And so that's why it's even more important to take that breath, to step back. And what I'm going to tell you here is to look at your infrastructure again. And let me give you an example. The biggest change that we've had to the law as a result of COVID has been the Families First Coronavirus Response Act and the Emergency FMLA Act that has expanded the reasons that people can be off work for FMLA purposes and provided everyone with 2 weeks of paid sick leave. And so the question I've been getting is, everybody's like, oh no, it's going to, expire in December. And then what are we going to do? Well, what you're going to do is go back to your pre-COVID leave policies. That's scenario 1. Scenario 2 is, once we get into cold and flu season, it very well might expand even more, or all the employees might be given an option again to have a fresh set of leave. So be prepared for both. Don't panic, just be prepared. So scenario 1, we're going to go back to pre-COVID, or 2, it's going to be expanded in some way. Discrimination laws. I still want you to think about all the, and I call them my alphabet soup ones, all the discrimination laws, ADA, FMLA, all the reasons that your mom told you to be nice to people at work. We don't discriminate against people, not even in a good way, right? So if there are a group of individuals that are more susceptible to COVID, and we know who they are, they're older, ADA, okay? So we can't use age, all right? We can look at some people and realize that they're a little overweight. Okay, we know that some young ladies are pregnant. All of these people are in the workplace, but even if you're motivated by benevolent concern, employers cannot treat vulnerable classes of employees differently. So don't carve out and let somebody work at home that you think is susceptible to COVID, but then are requiring people of the same classification to come into the workplace. And our favorite topic of telework and childcare issues. No one thought that we would not be going back to school in September. So long term, what kind of decisions do we want to make about children being out of school? And then are we just going to start firing people, or maybe they are protected, maybe they have not used all of their FFCRA leave yet. So we need to start planning for that. Can your municipality continue to run depending on the percentage of parents that cannot come back to work? How much of the workforce is doing telework? Are we going to permanently fire people for a short-term problem? So those are a lot of the questions. And hopefully over the summer, some of you have been looking at these. So just make the best decision for your municipality, but make it in the sense of this problem will go away. I know I said earlier on the other side that it's kind of a permanent problem, and so once it is, then you need to bargain with the union. But in terms of your workplace, having employees, maintaining loyalty, and knowing that this will end, that's how you should let those decisions guide you. Hiring practices. This one's really interesting. And I just saw this morning that the city of Ann Arbor is going to hire a class of police officers. How are we going to do that right now? Okay, so if you have instructors, they can be online. People can do certain things online, but when you're talking about public safety, how are you going to bring people into an academy? How are you going to get them through the physical portions of what's required? And so then we're talking again about cleaning, sanitizing, meeting OSHA standards, having small groups in large spaces. Maybe you're not going to be able to have your whole class in, or maybe you're only going to hire 5 to 10 people at a time. Those are all the questions that you have to sit down with human resources, and human resources then goes through, and what I would recommend is having that chart of how it was done in person and see how close you can get it to being offline, and then only what is absolutely essential to be done in person to then do that in person. What you don't want, and I'll take it out of the context of public safety, if you're hiring office workers, okay, don't have some people do video conferencing and then some people do interviews not video conferencing. Then it's not an equal process, and that's what opens us up to the liability and the litigation. I didn't have the same process as so-and-so, and then that's when you start going back and really looking at the processes. The EEOC has stated that if you've made a job offer and the individual has COVID or symptoms of it, then the offer can be withdrawn. So I'm gonna caution you against doing that because symptoms of it, that is so generic at this point. Anything can be COVID, okay? You can have a headache and it's COVID. You could come down with allergies and it seems like COVID. So now somebody has quit employment. They're supposed to be hired with you and you've kept them from getting a job. You are inviting a lawsuit, okay? So if someone does say that they're ill, I would say move that start date, right? And you can't keep doing that. You might say as a one-time for your offer, we're going to move your start date. And then after that, you can go to withdrawal. But this is something that's on the horizon as we're going to be doing more and more hiring in this COVID environment. And that's another fact that I want you to think about. All right, Bob, I'm going to turn it back over to you.
All right, thank you. Well, the next two topics I'm going to be speaking on deal with what we call sunshine laws in the state of Michigan. The first we're going to talk about is the Freedom of Information Act, or what is commonly known as FOIA. As I mentioned, it's a sunshine law, which means it is a pro-citizen law. Typically, when challenged, municipalities oftentimes have a hard time justifying why they failed to produce a document. What the design of the Freedom of Information Act is to allow citizens to be able to keep track of what their government does, and it's a mechanism for them to request government documents, or referred to as public documents. The key to this act from a municipal point of view is that it deals with written documents. Oftentimes I get calls from clients who say, hey, the person's requested this, we've talked about this, blah, blah, blah. I'm like, well, do you have the written documents they've requested? No. Then your answer is, we don't have the documents. You do not have to create a document to respond to FOIA. It is requesting something that already exists. If it does exist and it does not comply with one of the exemptions, then you must produce it. If it does not exist, the answer is it does not exist. Oftentimes, too, FOIAs will require redaction. You'll be able to comply with part of the Freedom of Information Act request. Some of it you won't. Your city clerk, or who's typically the FOIA coordinator, your FOIA coordinator is the person who should be, for the most part, handling responses to these particular requests. The reason being is they have the expertise to know what should or should not be produced and what are the magic words to require this. So if you get a Freedom of Information Act request as a municipal officer, my advice is to turn it over to your FOIA coordinator, or if you don't know who that is, to your city clerk or your township clerk as soon as you receive it. There is specific time periods in which responses must be made. There's extensions that can be requested. But again, you want to have this in the hands of somebody who knows what they're doing. Now, I'm not trying to teach you how to avoid FOIA issues, but I will tell you this. Documents include emails. So if two city commission members are emailing one another about an issue, that is a FOIA-able document. Now, I've always recommended that each municipality have a separate email account for each municipal officer, and that the municipal officers only use their municipal accounts to deal with municipal business. The reason being, if we get a FOIA and I've got to call you up and say, hey, listen, I just want to confirm that there's nothing on your personal computer at home or your personal server that deals with any emails pertaining to official municipal business, and your answer is, oh, no, I use it all the time. Well, that might be a problem. You're going to have to produce all those emails, any responses you got to those emails, if the FOIA requests it. And if challenged, it is not out of the ordinary that a court or another attorney could request that your server be checked to make sure that you have not deleted any emails or you're not withholding emails that you actually still have on your server. Again, that is not typical, but it certainly does and can happen. The best way to avoid it is to have a personal account with your municipal body or your city or your township or your county, and only use that for city business or township business or county business. That way you have nothing to worry about. Now, it is very important what you put in these emails. I've had a situation where a city council member said some rather unkind words about a citizen on a few occasions, and when election time came up, that citizen decided to FOIA any and all written documents, emails, or anything in the city's possession that made up a document where that person's name was mentioned. And I had to tell the city council member, hey, you've got to produce it. There's no exemption for this. And it made the guy look pretty bad too. So be very careful. My advice is don't put anything in writing as a municipal officer that you wouldn't want to read about on the front page of your own newspaper, the newspaper your mother and father read every day, and on the front page of USA Today, because it may just end up there. So don't put something in writing you don't want someone else to see, period. Now, how do you get around sensitive subjects where you don't want to have to worry about, you giving an opinion or question on something and have it pop up in an email? Well, the easiest way is to make a phone call. Phone calls aren't FOIAble. Nobody can FOIA a phone call. There's no transcript that has to be made of it. Maybe if you're the president, it's a little bit different, but at the levels we're dealing with, no. So pick up the phone and call the person. Nobody can FOIA that. Meet in person. Again, nobody can FOIA an in-person meeting. It's when people start using emails to communicate with one another about how things should be or how things are, or whatever it is they're talking about, that's when they get in trouble. So that being said, I think we've scratched on FOIA. I could teach a class on this for a week. Again, my advice is read the Act. There's several exceptions to FOIA that apply. One of them, too, real quick before I turn you back to Sydney, is what's called the attorney-client privilege. If you write me an email seeking legal advice and I give it, excuse me, that is not subject to Freedom of Information Act request. That's exempt, and you can claim that exemption. However, if the group said the city council wants to communicate with each other and it has nothing to do with legal advice, but you copy me on that, that doesn't mean just because my name appears on the email or because you CC me that it's exempt from FOIA. It's got to be something that would be covered by the attorney-client privilege. That is typically where you're asking for legal advice or I'm giving you legal advice, not Bob's name's on there, so it's protected. I've seen people try that too. That doesn't work. So please don't use that as a subterfuge or think it'll work. But again, in the end, go to your FOIA coordinator, talk to him or her about, hey, what do we do in this situation? You can always consult with your municipal attorney too, who should know the act. But just remember, it is in the end, it's a pro-citizen act. So with that being said, Sydney, it's back to you.
All right, Bob. I just want to dovetail on something you were saying. I can't remember what platform it was. It might have been Zoom, but whatever video conferencing software you decide to use for your municipality, be aware of what can happen on the other end. So if somebody on the other side of that video conference, or if they're sitting in the quote unquote audience of your city council meeting, there have already been requests for video transcripts and pictures and whatever is appearing on the screen. So you want to keep that in mind once you're choosing whatever platform that you want to use during this time. So I've already talked quite a bit about having people respond to COVID. So if you've got your COVID team for your department or your city as a whole, don't let this become your weekly snooze fest. This is a serious meeting. It's going to keep going on for some amount of time. If you are lucky enough to be in a community where you don't have COVID spikes right now, that's awesome. So start planning for what you want to do in the coming winter months. And with that, the most important thing that comes to mind for me, and I'm kind of biased since I'm from the fire department, but we want to focus on the people who are going to be exposed to COVID on a daily basis, and that is your public safety personnel. So we have to remember that what the CDC in the state of Michigan, what their guidelines are, they're just that. They're just guidelines. So if your city can sustain more robust countermeasures, I would do it. And I want you to think about, that one point over the summer, CDC said, oh yeah, it's fine. First responders, they can wear handkerchiefs and wash their N95 masks. And if you recoiled when you heard that, or you thought, that doesn't sound right, that's because we all knew it was outside the realm of acceptable personal protective equipment for our first responders. But what we have to remember, and what we keep seeing in the news media, is that all of these agencies have to operate at a bird's eye view, because they're looking at the entire country, they're looking at the entire state of Michigan. Sometimes they are changing the minimum standards that are required. just so agencies can stay open and they can stay operational. And that's because if we have another supply shortage, then you'll see them change again so that agencies can keep operating. And we don't want that. And so what you want to do is plan, prepare to have PPE for the coming months for your public safety personnel. And don't forget your police, because, well, they're not wearing PPE. Well, they're in a squad car and they're exposed. So their duty belts, their gear inside of the squad car, those are all the things that are still going to be subject to that ongoing commitment with OSHA, with cleaning and sanitizing every single shift. Not every single day, every single shift. The biggest change that I've seen, and it affects workers' comp, it sort of goes along with the public safety officers' benefits. And so those have now been expanded to include deaths of officers from COVID. And so there are two qualifications for that benefit. And it says that the officer has to have been engaged in line of duty actions during which the officer was exposed. And it must have been within a time frame where it was medically possible to have contracted COVID during that time. So keep that in mind. All of your public safety personnel, they may be subject, unfortunately, if they pass away, to this new public safety officer's benefit. Responsibility to the community. So we're going to talk about this a little bit in the next section as well in the press relations, but the most important thing we can do right now is we're thinking about our employees, and that's what I've been talking about this whole presentation. But what about all the people that come into your building? Okay, so if we're looking at permits, inspections, court proceedings, access to personnel, what are you doing to keep the public safe in your building? We used to think of just, oh man, now I got to go sign this piece of paper again because we're doing sign-ins, right? It's a cursory type of function, but now it's essential to contact tracing. So if you have an employee that's working as a teller, at a service window, and they get sick during the shift and they have to go home, but now from your sign-in sheet that they've interacted with the public all day, you know who that is, and you have phone numbers for them. You can comply with the health requirements for Wayne County, Oakland County, whatever county you happen to be in, to do that contact tracing. And so we want to think about our employees, but we're also thinking about the community in terms of the employees' interaction with the public as well. And with that, I'm going to turn it back over to Bob.
Thank you, Sydney. Next topic is the Open Meetings Act. This, again, is a topic that I think I could probably teach a week-long class on, but we're going to try to do it here in a couple of minutes. The Open Meetings Act is another sunshine law. It applies to all public bodies, and it says that all meetings where a decision is made has to be made in public. And this applies, again, to all public bodies. What is a meeting? A meeting is a convening of a public body in which a quorum is present for the purpose of deliberating towards or rendering a decision on public policy. Now, most people say, well, that's pretty easy to figure out. I mean, obviously, if we have a city council meeting and we have a quorum present, we have to have an open meeting unless it falls under the closed session rules. Well, that is easy to figure out. But here's another one that you got to watch out for, is say you have a 7-member city council board, and 4 of your members decide to show up at a planning commission meeting. The meeting's been noticed as a planning commission meeting, not a joint meeting of the city council and planning commission. And with 4 of you there, you have a quorum. If you begin to engage and deliberate with the planning commission, you now are deliberating towards or rendering a decision on public policy. You have violated the Open Meetings Act because you did not notice it as a joint meeting. You have a quorum present, and you are meeting, and the purpose of the meeting is to deliberate towards or render a decision on public policy. Another area you got to be careful of, I know this sounds nitpicky, is after a city council meeting, everyone decides they'd like to go out and have dinner together. And out of the 7 members, 5 of you go. You again have a quorum. If you start deliberating towards some type of public policy issue, you have violated the Open Meetings Act. So it's just very important that you're careful about who's around and what you do. Now, if 5 of you show up at a dinner party and you're all there, it's not an open meeting. If you have a chance meeting at some type of event, it's not an Open Meetings Act violation. It's just when you are together in a quorum and you just deliberate towards a decision on public policy. Now, the question next is, what is a decision? Well, the Act defines a decision as a determination, action, vote, or disposition on a motion, proposal, recommendation, resolution, ordinance, bill, or measure on which a vote by members of a public body is required, and by which a public body effectuates or formulates public policy. The key word in there that I want people to be very careful is the word recommendation. I often hear, well, this was just a planning commission recommendation to the city council. It wasn't an official action. Yes, it is. That's a decision under the Open Meetings Act. Where does that decision have to be made? In an open meeting. Now, because we're getting short on time, public notice, the Act, usually your clerk's going to handle that, but it has to be noticed. Meeting minutes have to be taken in both open and closed session meetings. The public has a right to speak at your open meeting, even if it's off topic. If your public body has rules as far as how long the time period is for that person to speak, fine, you can enforce them. If you don't, you've got to be careful. But if you have a meeting and somebody wants to talk about their displeasure with the United States government or some government in China, you got to let them speak. Also, if somebody shows up with a videotape recorder or a court reporter, they're allowed to do that. They're allowed to record the meeting. With respect to closed session meetings, these are tricky. They have to be expressly authorized under the Open Meetings Act, which I would highly recommend everyone take time to read. It is a grand total of, give me a second here and I'll tell you, 7 pages, and most of it you don't even need to look at, but it's worth taking your time to read. That talks about what going on in a closed session meeting. Typically, we'll see that happen is to discuss an attorney-client privilege communication. The key there is communication. It's got to be a written letter you're talking about, and it can only be on the topic you discuss. Again, going back just quickly to these decisions being made, again, the decisions have to be made in a public session or in a session with the public body. They cannot be made over the phone. They can't be made over email. And then you go into a public meeting and just simply say, okay, let's call this, controversial issue to a vote. There's no discussion. There's a first, a second, then a vote. People are smart enough to figure that out. They're going to turn around and say, I want to FOIA every comment you made regarding this subject. And what they'll find out is that somehow you did a round robin on email, or somehow this is already hashed out before you walked into the room. Those deliberations towards that decision cannot go on without being done in a public meeting, or you violate the Open Meetings Act. Now, if a commission member contacts another commission member, there's not a quorum present, different story. They're allowed to do that. Remember, the key to violating the Open Meetings Act is to have a quorum present. If there is a quorum present or a quorum involved, this act is triggered 99% of the time. So again, this is one of those great things where if you can act with your own attorney before your city attorney or township attorney, before you do whatever it is you're going to do, if you have a question about it, I highly recommend it. Because once you violate the act, you violate the act. The penalties for violating the act can be undoing whatever it was that was done. If the violation is determined to be intentional, it can be a misdemeanor, which nobody signed up for when they wanted to be a public official. So with that being said, our last topic today is something we're both going to speak on, is press relations. And Sydney, I'll turn it over to you and then just kind of jump into where I need to.
Oh, sure. Yeah. So I had quite a bit to say about this to run out of time. I just want to bring a couple of things to the forefront, and that is, do not share your police strategies in order to garner favor from the public. And I just read that word for word because I thought it was that important. because the executive orders are changing every single day. You don't know what's going to be enforced or not enforceable, and you don't want to misspeak. So if you are an official or anybody in your city is an official, you make sure that the message that comes out from city government is the message that you want out there, and it needs to be nonpartisan. And you might think, but I can garner some favor from my constituents. Please don't do it. And I think Bob will back me up on that. And then the last point that I wanted to say was, your community expectation is not to have a political war. Your community expectation is that you're going to tell them where they need to get food, how their kids are going to go to school, and how safe it is for them to be out and about in the community right now. Those are my points, Bob.
And just a quick point on my end, I think City's covered it perfectly, is, make sure if you are going to speak that you're speaking along the same lines as the rest of the municipality. Meaning, if you don't know the answer to a question, then your response should be, I don't know. Most often, communities have point people you can go to. I know in one of the cities I represent, it's the city manager. If there's a question, it's directed towards the city manager. That way, the municipality speaks with one voice, not 7 different voices. And again, when we talk about keeping people out of the soup, sometimes people like to answer questions to be polite and courteous when they have no idea what they're answering or what they're even talking about. And that's where the trouble begins. My recommendation is to typically have a point person, have everyone know who that point person is, and that way questions can be directed to that point person, and you'll have a consistent message most of the time. And again, we'll keep everybody out of the soup. So with that being said, John, I will turn this back to you. I think we've completed our portion of what we accomplished today.
Yeah, you guys did great. You hit the number right on the nose. We've got a couple minutes left. So I just want to remind everybody that we do have our questions queue in GoToWebinar. So if you want to type in a quick question, please do that now, and we'll try to answer those before we run out of time here. Bob, I wanted to ask you a question just as we wait for people to get on the line and type any questions they may have. You were talking about FOIA and OMA quite a bit, and I was wondering about texting. Do you have any thoughts about texting and whether that could get folks in trouble? Just thinking they're doing something harmless. And I know you mentioned the quorum issues and things like that.
I would treat text like emails. It's something that can be produced or printed, and it's in writing. So I would certainly treat it that way. I would highly recommend that anything you put in a text, a tweet, on Facebook or social media that has to do with a political issue, and your position as a political officer, you may have to, especially if your city has a website or a tweet site or whatever, that might have to be produced. So say the city's got a Facebook page for the city, and somebody's on there. That stuff is FOIAble. Yeah,
sure is. Thanks for that. Okay, we don't have any questions in the queue, so I'm going to take it that you guys just did a bang-up job on this. And of course, our attendees will definitely let us know their feedback, because we are going to send you, how about that for a segue? We are going to send you a post-webinar survey. So we want to thank you for coming, but we also value all the input you have for us about how we did today, but also about topics you may want to see us cover in the future. So if you could, please respond to that survey, and it should pop up when you log off. Today's presentation is being recorded, and we'll have that, as I mentioned early on in my initial remarks, on our website at plunkettcooney.com. Just look for this presentation under our events section, and at the bottom there'll be a recording, so feel free to take a look at this again if you need to, or certainly share it with colleagues who may benefit from the information. So really, that's our program for today. On behalf of Bob and Sydney and all the folks in our governmental law practice group here at Plunkett Cooney, we want to thank you for being part of this program today. Hopefully you found it valuable, and we will see you at our next event down the road. Thanks so much, and have a great day. Be safe out there.